We will start our session in 1 minute. Hello, everyone, and welcome to SCORE Fairfield County's webinar on Human Resource Essentials for Small Business Owners. My name is Peter Talion, the workshop coordinator and a business mentor here at SCORE Fairfield County, and I'll be your host. Our speaker today is Kimberly Farrar-Powell. More on our speaker in just a moment. First, some brief information on SCORE. SCORE has approximately 220 offices nationwide with 10,000 volunteers. We are a resource partner of the Small Business Administration. In Fairfield County, SCORE has about 100 volunteers with a wide range of industry, process, and subject matter expertise. We offer 3 primary value-added services to small business owners: free one-on-one counseling, educational in-person workshops and live webinars, about 100 per year, and extensive resources on our website, including a network of subject matter experts at your disposal. Some useful information about today's event. If you have a question, please use the Q&A function at the bottom of the page. Our workshop will end at 1 o'clock to respect your time. The session is being recorded, and the link to the recording will be available at fairfieldcounty.score.org within the next couple of days. Now it's my great pleasure to present Kimberly Farrar-Powell. She's an accomplished human resource professional with over 20 years of experience in the nonprofit sector. She earned her Bachelor of Science in Business Management and a Master's in Organizational Leadership with a focus on human resource management from Quinnipiac University. Kim is currently serving as Human Resource Director at a nonprofit organization in New Haven, Connecticut. She brings a wealth of expertise in managing human capital and developing strategic HR solutions. In 2024, she expanded her professional scope by founding KFP Consulting Services, a human resource consulting business aimed at helping organizations optimize their HR functions. I will now turn it over to Kimberly. Kim, it's all yours.
Hi, good afternoon, everyone. Thank you for joining me this afternoon. So I'm going to be talking about or discussing human resource essentials for small business owners. I'm excited to discuss the HR essentials for small business owners. Whether you have 1 employee or 50, understanding HR best practices is key to protecting your business and fostering a great environment. Today's session will be interactive, so don't hesitate to ask questions. Many people think HR is just about paperwork because they often associate it with administrative tasks, like processing payroll, managing benefits, handling employee records, and overseeing hiring paperwork. These visible tasks make HR seem like a purely bureaucratic function. However, HR is much more than just paperwork. It's about ensuring businesses follow labor laws and avoiding illegal risks, creating a positive work environment, improving employee engagement, and fostering a diversity and inclusion, handling workplace disputes, preventing harassment, and implementing safety policies, recruiting, training, and retaining the right people for business success. HR plays a strategic role in business growth, employee satisfaction, and risk reduction. The paperwork is just a small piece of a much bigger picture. Throughout our workshop today, I will have scenarios on various HR compliance issues that many businesses face. Here is our first one. Lisa, a small business owner, was passionate about her bakery, but had no HR experience. At first, she managed everything herself, the hiring, scheduling, and payroll. But soon problems arose. Without structured interviews, she was hired unreliable employees, leading to frequent call-outs and poor customer service, which is a hiring mistake. Lisa unknowingly misclassified employees as independent contractors, resulting in fines and back taxes, which caused legal trouble. Without clear policies, workplace disputes escalated, creating a toxic work environment and high turnover, which resulted in employee conflicts. Juggling HR tasks, while juggling HR tasks with running the business left Lisa overwhelmed, making it hard for her to focus on growth, which caused her burnout and stress. Eventually, Lisa realized that HR isn't just about paperwork. It's essential for stability, compliance, and employee satisfaction. Learning and seeking HR guidance helped her regain control and build a thriving team. Today, we're going to break down some key topics that every business should understand. Employee rights, what are they and how to respect them in your workplace? Labor laws, especially the ones that apply here in Connecticut. Common HR pitfalls and how to avoid those costly mistakes. And most importantly, how to stay compliant as laws and regulations change. There's no legal jargon overload, just real world practical information that you can use every day. So let's dive in. Employee rights. What are employee rights? Employee rights and how they have evolved over time. Many small business owners still hold on to an outdated mindset is saying, it's my business and employees have to do what I say. This approach doesn't align with modern labor laws and can expose you to legal risks. Let's dive into why understanding employee rights is crucial. EOE, I know everyone heard of that, it's called Equal Opportunity Employment. These laws aim to ensure that individuals, regardless of background or personal characteristics, are treated fairly and equitable in the workplace. EOE covers a broad spectrum of protections against discrimination for job applicants and employees. Specifically ensures that employees who do not discriminate based on the following protected class categories: race, color, national origin, sex, religion, disability, age, pregnancy, genetic information, and veteran status. Who is covered under the EOE? EOE laws apply to a wide range of employees and job applicants. Private employers, all employers with 15 or more employees are subject to EOE protections under federal law. Under federal contractors, companies with federal contracts or subcontracts must also comply with affirmative action and equal opportunity requirements. State and local laws. Many states and local jurisdictions may have additional protections that expand on federal EOE laws, covering smaller employers providing more specific protections. It's important to note, while federal laws cover a broad range of discrimination protections, state and local laws may also offer even more comprehensive protections, depending on the jurisdiction. For example, some states provide protections based on sexual orientation, gender identity, or other characteristics not covered under the federal law. In summary, EOE covers all employees and job applicants, ensuring that they are not discriminated against on the basis of protected characteristics, and that they have equal access to opportunities and fair treatments in the workplace. Another employee right is the anti-discrimination and harassment laws. Following these laws are important because they build a respectful and productive workplace. It also builds it builds a respectful, productive workplace and also prevents lawsuits and boosts employee morale. The key laws to remember for anti-discrimination and harassment laws is the Title VII of Civil Rights Act, which states no discrimination based on race, sex, or religion, and that includes any employer that has 15 employees. The ADA protects employees with disabilities and requires accommodation. ADEA protects protects workers 40 plus in age discrimination. The Connecticut law covers more areas like sexual orientation and gender identity, and that includes any employer that has over 3 employees. What are some types of discrimination? Discrimination can be based on race, religion, sex, age, disability, and pregnancy. What is sexual harassment? Sexual harassment includes unwanted sexual advances or conduct. Employers must prevent and respond to it right away. The employer's responsibilities are to create clear and anti-discrimination harassment policies, train employees regularly, investigate complaints, and offer accommodations when required. Make sure you have a no retaliation protections in place. It is illegal to punish employees for reporting discrimination or harassment in the workplace. You would all employers should always foster a safe space for reporting and documentation. One of the things I want, especially for small business owners, that to really consider is that law requirements vary from business to business and depending on their size. Even small business must comply and foster inclusion. There are penalties for noncompliance, and employees may file with the EEOC or the CHRO. Penalties include damages, legal fees, and loss of reputation. The best practices is to have clear policies and train your staff. Act quickly on complaints, promote fairness and inclusion, and the bottom line is to take proactive steps to protect your people and your business. At will versus a contract employer. In Connecticut and in many other states, an at-will employment is a default employment relationship unless there is a specific agreement or contract in place. At-will employees and contract employees lies in the terms and conditions of the employment, especially regarding termination and job security. Let's break down the differences between the two. So at will employment means that either the employer or the employee can terminate the employment relationship at any time for any reason with or without cause, unless there's a specific contract or agreement that overrides this principle. The key characteristics of an at-will employment: determination, flexibility. An employer can terminate the employee at any time for any legal reason or even no reason at all. Similarly, the employee can quit the job at any time without giving notice or providing a reason. There's no long-term job security. At-will employees do not have a guaranteed length of employment and are not protected against being terminated unless the reason is illegal, for example, discrimination or retaliation. Here are some examples of at-will employment. Mostly hourly or salary employees in Connecticut and across the US are at-will employees unless stated otherwise in an employment contract or a collective bargaining agreement. Some exceptions to at-will employment are illegal discrimination. Employers cannot terminate an employee based on race, gender, age, disability, or other protected categories. Retaliation: employers cannot fire an employee for asserting their legal rights, such as reporting workplace safety violations or participating in a discrimination lawsuit. Public policy violations include employees cannot be fired for reasons that violate public policy, such as refusing to take a break, to break the law, or taking family or medical leave. Now, contract employees. Contract employees, on the other hand, are hired based on specific employment contracts that outlines terms and conditions of their employment, including job duties, compensation, duration of employment, and grounds for termination. Here are some key characteristics of a contract employee. A contract employee usually has specific employment terms such as 1 year or 2 years, or the duration of the particular project. Their employment is not at will and cannot be terminated arbitrarily unless certain conditions are not met, such as a breach in contract, a mutual agreement, or specific termination clauses. Contract employees typically have greater job security than at-will employees. They can only be terminated under the terms specified in the contract. For example, the employer may only be able to terminate the contract for specific reasons such as misconduct, failure to meet performance standards, or other breach outlined in agreement. The contract will typically outline how the contract can be ended early by either party. This might include providing notice, severance pay, or penalties for early termination. What is a contract employee? A contract employee could be a professional like consultants, independent contractors, certain executives, employees hired for a specific project may be hired under a contract. Also, too, there can be a contract to hire. Employers are often hired initially on a contracted basis with the potential to transition into a full-time position if certain terms are met. Now let's discuss the wage and hour laws. As of January 1st, 2025, the minimum wage in Connecticut went up to $16.35 per hour. Tipped employees must be paid a minimum of $6.38 per hour. Employers must ensure that tips combined with wages meet the regular minimum wage of $16.35 per hour. What is overtime and who is eligible? Employers who work more than 40 hours in a work week must be paid time and a half for each hour worked over 40. They are called non-exempt employees unless they are exempt under federal or state law. And that is, there's certain executive, administrative, and professional uh, titles that would go under that law. We'll talk about that a little bit later in this presentation. The overtime rate is 1.5 times the regular hourly rate. It is required that employers give breaks and rest periods. Meal breaks are for meal breaks are for employees are required to provide a 30-minute meal break to employees who work more than 7.5 hours in a workday. The break must be given within the first 6 hours of the workday. Rest periods. Connecticut law does not require additional rest breaks, but if breaks are given, they must be paid, and if they are shorter than 20 minutes. Wage deductions. Employers can deduct wages for taxes, insurance premiums, or other benefits. The deductions for items like uniforms or equipment can only be made if the employee agrees in writing. Equal pay for equal work. Connecticut law prohibits wage discrimination based on gender. Men and women must receive equal pay for performing equal work in the same establishment. Record keeping. Employers are required to keep accurate records of each employee's hours worked and wages paid. Records must be kept for at least 3 years. Enforcement and penalties. Enforcement and penalty. Employers who believe their rights under wage and hour laws have been violated can file a complaint with the Connecticut Department of Labor. Employers who violate wage and hour laws may be required to pay back wages, penalty, and interest, and they may also face fines and other legal consequences. We have another scenario. A business owner is accused of favoritism in promotions, leading to a discrimination complaint. How could clear policies have helped? I don't know if anyone wants to put anything in the chat box. The answer: by establishing clear promotion criteria and documenting decisions can prevent bias or unfair treatment claims. All right, let's employee benefits and leave protections. Connecticut mandates paid leave for certain situations, so be aware of eligibility and compliance requirements. So I'm going to go over some of the different types of leaves that are required in Connecticut, and I will tell you what is required or what the employee is entitled to. Later on in the presentation, I'll tell you what piece the employer has to do with these protections. So Connecticut offers the CT pay leave. And the CT pay leave, like I said, we'll discuss it a little bit later in the presentation on the employer responsibilities, but any employer with 50 or more employees has to allow employees to take sick leave. Employees can take this type of leave for personal illness, medical appointments, care for a sick family member, and also for a mental health day. This hour should always be taken in 1 hour increments. The paid family and medical leave. This is a benefit for employees who have earned $2,325 in the highest earned quarter. This could be taken for personal illness, caring for a family member, bonding with a new child, and can be taken up to 12 weeks of paid leave. The employee can take up to 95% of the weekly wage, capped at $900. The Family and Medical Leave Act, FMLA. Employers with 50 plus employees who worked over 1,250 hours in the last 12 months are entitled to family and medical leave. This leave can be taken for personal serious health condition, a family member's serious health condition, childbirth, and adoption. This leave can be taken up to 12 weeks of unpaid leave, and this is for job protection. Connecticut also offers the Connecticut Military Family Leave. Employees with a family member in the military, this leave can be taken to address issues related to family members' military service, such as medical care or legal assistance. This also can be taken up to 12 weeks and it can be combined with a paid family medical leave. Some other leaves that Connecticut requires are the voting leave. If an employee has a scheduled conflict during voting time, he or she can take up to 2 hours to vote in an election. And also there's leave for domestic violence victims. Employees may take time off to address issues related to domestic violence. In conclusion, Connecticut provides various types of leave to support employees in times of illness, family emergencies, and personal matters. Employers must comply with state laws and ensure employees are aware of their rights. Employee right takeaways. Okay. Know your responsibility as an employer when it comes to employee rights. Ensure clear policies and handbooks and provide trainings. Respect workplace rights to avoid costly disputes, sorry. So now let's discuss Connecticut labor laws. Some of the risk of misclassifying employees as exempt. This is misclassification of employees is something that happens a lot in a lot of employers. So I'm going to just discuss what that misclassification is and what those mean, and also too what you can do to prevent this from happening. So I'm going to give you an example of a prime misclassification. So there's an assistant manager in a retail store, and he's classified as an exempt employee, which they're paying him $900 a week. But in reality, the employee has some managerial skills, scheduling, opening, closing store, and they spend 80% of their time on a non-exempt duties. Non-exempt duties such as stocking shelves, cashiering, and helping customers. The primary duty test for exemption isn't met because their main role is non-exempt work. The consequences for this is that an employee should be a non-exempt entitled to overtime pay for any hours over 40 hours a week. Misclassification can lead to back claims, fines, and lawsuits. Misclassification can lead to the following: unpaid overtime violations, wage and hour penalties. Employers may owe up to 3 years of back wages, plus double damages under the Connecticut law. Tax and payroll issues. Misclassification results in unpaid payroll taxes, unemployment insurance, and workers' comp fines. There's also DOL and IRS penalties, which can be fined up to $2,074 per violation, plus audits and compliance reviews. You can also, an employer can also have the risk of legal fees and lawsuits for unpaid wages, attorney fees, and punitive damages. To avoid this mistake, follow the FLSA exemption test for salary and duties, and you can find this on the link below from the Department of Labor. Make sure to review employee job duties on a regular basis to make sure they are not misclassified. Also, one major thing to get out of this is please consult a legal or an HR expert for compliance assistance. Here's another scenario. A small business owner hires a new employee but forgets to provide a formal letter. Later, there's a dispute over expectations. How can proper HR practices have prevented this? I don't know if anyone wants to put anything in the box. You know what they could have done differently? So the answer would be a formal offer letter outlining pay, job duties, and expectations helps prevent miscommunication and legal disputes. Okay, so we're going to talk about a little bit more about the Connecticut labor laws pertaining to paid family and medical leave. So we're going to discuss a little bit more about this. The employer's responsibility. So as an employer, your responsibility is to contribute to this fund. Employers are required to contribute 0.5% payroll tax on employee wages split between the employee and employer. The contributions to this plan or to this leave started back in January 1st, 2021, and the benefits started January 1st, 2022. Employers are required to notify employees in writing about the availability of paid family medical leave. Also, too, it's the employer's responsibility to keep good record keeping when it comes to maintaining these files and on the contributions and the usage of the paid leave. Also, too, this leave can also interact with the other leaves, such as FMLA and CT paid leave, and they can run concurrently. Connecticut sick leave and vacation time. Employers should differentiate the medical leave and other types of leaves, such as paid sick leave or vacation days, which may be used separately or in a combination. Administering paid family and medical leave. The Connecticut Paid Leave Authority administers the medical leave benefits, not the employer. Employers do not pay out the medical leave benefit directly to employees. Employees, what they have to do is they have to apply through the state, it's through AFLAC, and employees must apply through the benefits through the CTPLA, which is called a Connecticut Paid Leave Act Authority, which reviews claims and provides payments. Your role as the employer, employers must verify the employee's eligibility and provide any necessary documentation requested by CT leave. Penalties for non-compliance and fail to contribute. Employers who do not make the required contributions to the paid leave fund can face fines and penalties. There's also retaliation. Retaliation is prohibited. Employers from retaliating from anyone from using any of the leaves. So employers cannot retaliate against employees for taking paid leave or medical leave, such as they can't be fired, demoted, or lose any other benefits. The key takeaway for small business owners is to contribute to the paid leave fund. All employers, regardless of size, must contribute to the paid leave fund, which started in 2021. Inform your employees about their rights and how to apply for the leave. Keep good record keeping and accurate record keeping because who knows, at any time there could be an audit. In conclusion, Connecticut's paid family medical leave program provides valued support for employees while balancing responsibilities of employers. Small business owners must be proactive in contributing to the program, ensuring compliance with state laws to avoid penalties and support the workforce. Understanding the Connecticut labor laws on the Connecticut sick leave. So as of January 1st, 2025, this new law went into effect with employers with 25 or more employees must provide sick leave. In January 1st in 2026, it'll apply to any employers with 11 or more employees must provide sick leave. As of January 1st, 2027, all employers with one or more employees must provide paid sick leave. The key changes and requirements for employers. The law now covers nearly all employees, not just those in retail and service jobs, which phased in approach for employers based on employee count. The accrual rate for the sick leave is at a rate of 1 hour for every 30 hours worked, with a maximum accrual of 40 hours per year. New employees can use accrued sick leave starting on the 120th calendar day of their employment. Carryover, employees can carry up to 40 hours of unused sick leave to the next year. Employers may choose to provide a bank of sick leave at the beginning of the year, which is called front loading, instead of allowing a carryover. as long as the leave satisfies the law's requirement and is immediately available for employees' use. Employers are not currently required to pay out accrued sick leave upon termination of employment. Employers must provide a written notice to employees about their rights to the paid sick time, either by January 1st, 2025, or at the time of hire, whichever is later. Employers must keep records of hours worked and paid sick leave accrued and used for every employee. Employers are prohibited from retaliating or discriminating against employees for using requested paid sick leave. Employers are prohibited from requiring employers, employers are prohibited from requiring employees to provide documentation to justify the use of paid sick leave. So according to this new law, if you have an employee that needs to take time, I know with some employers, they require that you have to bring in a doctor's note. With this new sick leave law, an employee, all they have to do is call in and say, hey, I'm going to take a mental health day, or I have a doctor's appointment, and they're required, it's it would just have to be documented, either in your payroll or noted in something that's separate from any of the other leave time, as far as like with if you have a PTO policy in place or a vacation policy. So this sick leave has to be separated from that. And one of the things that is very important to note, especially with small businesses, is that um, they will eventually, there will be an audit. So this has to be separated from any other leaves or anything else that's your that you are asking your employees. Like, say for example, if like for example bereavement or anything like that. This If someone's taking bereavement, it has to be classified as bereavement. Sick time has to be classified as sick time. So, like I said, at the end of the year, they will be auditing and be looking at this. So, if you fall into any of these categories as far as an employer, um, like I said, in 2025, it just hit us for 25 employees. And in 2027, it's going to go down to all employees. So one of the things that I definitely tell small businesses or all businesses is make sure that you have something in place before this time hits, because, it's a very costly and it could be very detrimental to your business. So the best thing to do is be proactive and definitely try to put a policy in place and put things in place before your time frame. We have another scenario. A restaurant owner fires an employee who just informed them about a medical condition requiring time off. The employee files a wrongful termination claim. What should have been done differently? Does anybody know? Does anyone want to put anything in the chat box? Okay, the answer. Their employer should have reviewed Connecticut's paid sick leave laws, engaged in a discussion with the employee, and explored reasonable accommodations before making a decision. Now we're going to talk about Connecticut's harassment laws. CT harassment laws requirements regarding sexual harassment training and education. These provisions were requirement when it went into effect on October 1st, 2019. The language which applies to employers which have 3 or more employees, which includes employees are required to provide a new employee a copy of information regarding the illegality of sexual harassment and remedies available to victims. As of October 1st, 2020, employers have to provide all existing employees with 2 hours of training. Employers must provide 2 hours of training and education to new employees hired on or after October 1st, 2019, within 6 months of their start date. Employers with fewer than 3 employees must provide 2 hours of training and education to all existing supervisory employees by October 1st, 2020, or within 6 months to new supervisory employees. Employers must provide periodic supplemental training, not less than every 10 years. As a rule of thumb, I recommend all employers to have this training on a yearly basis as a refresher. The benefits of the yearly training is it's easily trackable. and having a set yearly schedule makes compliance simple. It also reinforces your policies. It keeps policies fresh and on top of mind for employees. And regular training helps prevent claims and fosters a positive work environment. You can access the free training on CHRO website, which is listed here, and they offer that the training, the 2-hour training, and this is something that you can not only for yourself but also for your employees. So let's talk about workplace safety. It's the employer's job to provide a safe workplace. Employers must ensure a safe work environment by identifying and addressing hazards to prevent accidents and injuries. This includes following OSHA, which is Occupational Safety and Health Administration standards for workplace safety. Also, employers are responsible to provide workers' compensation insurance. Employers are required to carry workers' comp insurance for employees. This covers medical expenses, lost wages, and rehab costs for workers injured on the job. Employers with less than 3 employees may be exempt in some cases. Employers must report work-related injuries to the workers' compensation insurance carrier, the Connecticut Workers' Compensation Commission. Injuries should be reported within 1 week of the incident. Employers must also comply with OSHA recording requirements, including recording certain types of work-related injuries and illnesses on the OSHA logs. Employers must ensure that employees receive appropriate medical treatment for work-related injuries. Employers have the right to choose their treating physician for workers' compensation claims. Employers must not retaliate against employees for reporting on an injury or filing a workers' compensation claim. Or for example, there's no firing or the employee cannot even be demoted. Employers must provide reasonable accommodations for employees to return to work after an injury, such as modified tasks or light duty. Um, One thing is that employers have to do is maintain OSHA compliance. They must comply with OSHA regulations, including ensuring workplace safety by implementing safety programs and training, reporting serious injury, fatalities, or hazardous conditions to OSHA, keeping record of work-related injuries and illnesses on the OSHA log. Employers must keep records of workplace injuries and report them as required by OSHA and state regulations. Certain injuries must be recorded on OSHA's 300 log of work-related injuries and illnesses. In conclusion, employers are responsible for maintaining a safe workplace, providing workers' compensation insurance, and promptly reporting injuries, and accommodating injured employees, and ensuring OSHA compliance. And failure to comply can lead to penalties, fines, and legal consequences. So here's some key takeaways, this is a really great resource. This is a listing of various resources for business owners to keep abreast of the laws and the changing regulations. So have listed the CT Department of Labor in the site, and you can go there for wage laws, compliance, and labor posters. So we talked about the CT Paid Leave Authority. If you go to the site, ctpaidleave.org, and you'll get the information on paid leave updates and employer requirements. CBIA is a business-focused legislative updates. HR and legal resources, SHRM. SHRM is a great resource, the Society on Human Resource Management. And also you can get information from HR professionals, employment law firms for compliance assistance. So key takeaways. You want to stay compliant with wage and hour laws. You also want to document policies to protect your business. Another thing is use resources for updates and guidance on staying compliant. One of the things, like I said, creating a policy manual to protect your business from legal troubles is key. The slide before I talked about SHRM, the Society on Human Resource Management. They're a great resource, and it's a great tool that you can definitely use to get the outlines for policies, employment letters, anything that's HR related that you're unsure of. SHRM has it, and it's a great resource. but also to you also want to utilize resources for updates and guidance on staying compliant. A good rule of thumb is conduct a yearly HR audit. Make sure your business is compliant with the new laws. Also, make sure you have updated labor posters and posters that are posted in areas that your employees congregate. Here's another scenario. A company classifies a worker as an independent contractor, but the state later determines they should have been an employee, leading to fines. How could this have been avoided? Anybody? Conducting proper classification assessment using IRS and CT guidelines would have prevented misclassification and penalties. Here's another scenario. Um, it's called the "It's a Joke" excuse. This is the situation. Carlos, who owns a retail boutique, notices that his assistant manager, Dave, often teases younger employees about their looks in relationships. He calls "It's just joking," but some employees feel uncomfortable and Singled out. One employee, Mia, avoids working when Dave is on duty. So the answer to this scenario is intent doesn't matter, impact does. Even jokes can be harassment. Owners must correct inappropriate behavior early to prevent escalation. A simple, well-written anti-harassment policy and regular training can help small businesses avoid legal risks. Okay. Avoiding HR pitfalls. Here are some of the list of common HR pitfalls that some small businesses have failed. Not classifying employees in the right category as far as exempt and non-exempt. Small business must properly complete, retain, and verify I-9 forms for all employees to avoid penalties and fines. Consistency, accuracy, and regular audits are key to staying compliant with the I-9 requirements. Also, another keynote I always tell when I do my consulting is that I always tell people that I-9 documents do not belong in the personnel file. So they have to be kept separate. Um, the other thing is with your there's there's certain items that you want to keep in your employee records, which are their employee documents, applications, resume, job offers, personal information, date of birth, emergency contact, tax information, and benefit information. And also too, if there's any warning, disciplinary action, or leave requests, that also be kept in that personnel file. Also too, another pitfall is failing um, to train managers, and not training managers can lead to harmful to a small business for several reasons. Without proper training, a manager may apply inconsistent policies, leading to confusion, dissatisfaction among employees. Untrained managers may inadvertently violate labor laws such as discrimination or harassment, exposing the business to legal trouble. Managers without leadership skills may struggle to motivate and engage their teams, leading to low morale, high turnover, decreased productivity. Lack of training can result in miscommunication between management and staff. Overall, investing in a manager training ensures effective leadership, smoother operation, and a healthier work environment. Also, it's very key, put together clear policies to prevent issues. Putting in place clear and concise policies for your company would avoid huge legal ramifications. Good documentation is best defense. The key for HR, we always say document, document, document. Always document conversations with employees so everyone is on the same page. A good rule of thumb would be after meeting with an employee about an issue, always follow up with a conversation with an email. Also, another great tool, another pitfall is that a lot of small businesses do not invest in HR tools and training. And this is like what I was saying earlier, just joining certain certain organizations like SHRM, the Society on Human Resource Management for professionals, that can help you in staying compliant with your business. So always keeping in touch with what's going on in as far as any changes, as far as legal changes, as far as with employment is very key. Also to definitely sign up on DOL, and they do send out alerts when there's anything that's changing as far as if there's the wage change, or even if there's a new law coming out, like I said, like the new sick leave policy. This is the last scenario. A business doesn't update its policies to reflect a new state law and ends up paying penalties. How could they have stayed ahead of this change? Regular HR audits, legal consultations, and subscribing to labor law updates can help businesses stay compliant. All right. So, all right. So that wraps up our workshop portion. And thank you all for hanging in there and taking the time for this important information. Before we close out, let's take some time for any questions. Does anyone have any questions?
Thank you very, very much, Kim. An excellent presentation. If you've got questions, if you could put it either into the chat or in the Q&A box, that would be ideal. One other thing before we take some questions, Kim, if folks want to get a hold of you, what's your contact information?
Oh, yes, I'll put it in the chat box. Let's see. Sorry about that.
If you have a question, if you could put it into the chat or into the Q&A box. We can't do audio questions. So there's a question, this session has been recorded, so you can get a replay by going to the SCORE Fairfield, County website. The replay will be online within the next day. So a question for you, Kim.
Mm-hmm.
Is it illegal to change a salaried employee to an hourly rate?
No, it's not, and that's one of the things discussed during the presentation. Is what you would want to do is go on the Department of Labor website, and if you want to change, there's certain qualifications. It's called a duties test, and you want to make sure that if someone is going from hourly to salary, that you go through all the requirements of that duties test. And the link for that duties test is in the presentation.
Okay, thank you. If you want a copy of the slides, the best way of getting a copy of the slides is to write to Kim directly. Kim's email address is in the chat. So if you'd like to have a copy of the slides, write her an email and Kim will send you a copy of the slides. If you want a copy of the recording, go to the SCORE Fairfield County website to get a copy of the recording. And we've got a request. Can you repost your email, Kim?
Yeah. Yep.
So it's back in. It's kpowell@kfpconsultingllc.com. It's in the chat.
Yeah, and also, I mean, this is my expertise. I love HR, and I've been doing it for quite some time. And also, to like many of you, I started my business recently, so I know what business owners go through. But if you have any questions at all, even anything pertaining to putting together policies or making sure that it's just staying compliant, like I said, just you can email me and we can have a discussion, and just to see, what are you currently doing? Oh, they didn't see they can't see it.
Yeah, it's in the
Oh,
webinar chat.
oh, you know what it is? I see what it is. It's because it's only on the, all right, sorry about that. I think I just left it for the panelists. So hold on.
Okay.
That's what I just saw. I apologize for that.
All right, we'll get the email out there. Just hold on, folks. Okay, Kim's email is now available to everyone.
Sorry about that. I didn't realize I was on the wrong screen.
All right, well, thank you very, very much, Kim. Thank you very much,
Thank
all the
you.
folks who
Thank you.
participated. And we will bring this webinar to a close. Have a great day.
All right. Thank you.
Thank you.